my
Okay,
memorandum.
yes, the court does see the recommendation. Recommendation, Ms. Scott, is that the defendant father of sole physical custody of the minor child Isabella, and that the plaintiff mother have parenting time during the summer week on, week off. And the recommendation this morning from the met with Mr. Pratt, is that correct, sir?
That's correct, Your Honor.
Okay, go. Good morning, Mr. Pratt.
Good morning, Your Honor.
So the recommendation this morning is that that referee recommend order be adopted. All right, Mr. Savage, obviously this recommendation is agreed with your client. Is that correct?
I can't hear. I can't understand you, Judge.
Does your client agree with this recommendation, Mr. Savage?
Yes.
All right, the court would assume so. That's what I stated. Mr. Rosenberg.
We do not agree with the recommendation for a few reasons. Number one, it would be very traumatic to the child because the child had no contact with the father from when she was about 7 months old until 2023, when the prosecutor went after him for support. And even then he resisted by asking for a genetic testing because he didn't believe that the kid was his. Since then, he has seen the child once. At the time he saw the child, they didn't really interact all that well because they're strangers to each other. The child has no real contacts with the Upper Peninsula or the community that Mr. Corns lives in. The child lives with her mom and her half sibling and her grandfather and her mom's boyfriend in Temperance. That's the only place that she knows. The father has only contacted the child a few times by phone. We need to have some kind of way of reintroducing these people to each other because otherwise it's going to be very traumatic for the child. That's not in the best interest. Mr. Corns chose to move up north. So that creates a geographic problem here. Now, the week on, week off in the summer probably will work, but the child is used to being down here. This is her community. This is all she's known. She's not she's not acclimatized or familiar with that environment any more than she would be with a strange town anywhere else. She's just not from there. So what we would object to is, number one, the physical custody like that. We don't object to the week on, week off. I want the child, and my client wants the child to know who her father is and who his family is for themselves. But a lot of this is embarrassment about class. My client is very impecunious, and she's also rather unsophisticated. She's a store clerk who has a high school education. So when the court stuff happened to her, as best I can tell, she was overwhelmed, went into a shell, and foolishly ignored what was going on and didn't participate. She says she has technical issues with one of the hearings, and another hearing she tried to phone in and she had other issues. I wasn't there. I don't know. But to go ahead and to give full physical to the father and to rip the child from what she's known is not in the child's best interest. Mr. Corns, I don't know what his living situation is up north. I know it's different than my client's, but I believe that it's a fairly remote location. I also believe that it does not have the same amenities that you would have in southern Michigan in between Detroit, Toledo, and Ann Arbor. The child, I believe, is doing well in school. She's got her friends and relationships, and this would basically go ahead and squelch all of them. Is that in the child's best interest? Probably not. It would scare the pants off of her and make her feel insecure because there wouldn't be continuity in her life. So what I would suggest is that we hold off on making a decision on physical custody. We do some kind of joint physical custody, week on, week off in the summertime. We come up with some way of therapeutically reintroducing father and child, possibly through an app, so we have some kind of means of recording this so we know when people are calling or not calling, and we don't have a he says, she says. And we regulate it, and we revisit this in about 6 months to see how things are going. Because otherwise, this child is going to suffer a trauma.
Guys, a sudden custody shock hits the court. Tension rises fast as the mother's world turns upside down. Dad is painted as a total stranger. Fear and doubt grow with every heavy accusation.
When soldiers are in the foxholes, they don't scream for their fathers typically, they scream for their moms. This child's mother has been central to this child's life. To be ripped from her like that and say, I'll see you in 8 months or 9 months, that's forever for a 5-year-old. That's effectively forever. That's not in the child's best interest. So what we would want, and I know that Mr. Savage and Mr. Corns don't like my client's family structure, but she has a family structure. It's stable. She lives with her father, as I said. There's other people in the house. The child has her own bedroom with her half sibling. It's stable. It's good. There's no allegations of abuse of this child. The child should remain there, and we should try to reintroduce. Again, how we do this, because normally we'd say go to do it supervised at a location. That's obviously not going to work, because it'd be unfair to everybody to travel like that. So we're going to have to do it, I think, on the internet, or at first revisit it, maybe get some holiday parenting time at some point, and then go on and do it gradually as opposed to bang. That's what we're saying. So we don't, as I said, it's a partial objection to this. And it's also, we don't want the trauma, and I don't want this child saying, count down to June, and then it's bye-bye, and your life totally changes. Because that would freak the kid out.
All right, thank you, Mr.
Children don't
Rosenberg.
like uncertainty like that.
Mr. Rosenberg, did you review the affidavit of Dawn?
I don't believe that Don's affidavit is really relevant, and I'll tell you why.
Well, let me just ask you, Mr. Rosenberg, is it true that Miss Ashley Kuntz has her parental rights have been terminated to 2 of her other children?
That is true.
Okay.
But that happened years ago.
Is it true that the minor child shares one bedroom in her house with 4 other children?
That is not true.
Okay.
That is not
Who does she
true.
share a bedroom with?
And Dawn has no actual knowledge of that. She can't.
With whom does the minor child share a bedroom?
With the child shares a bedroom with her half sibling, whose name is
How many?
Bethany Bentley.
How many step siblings does she share a bedroom with?
1.
Okay. Obviously, the court's concern, I think it is relevant that the plaintiff's parental rights have been terminated to 2 other children. I don't know the circumstances behind that.
But Judge, that was 8 years ago. And that was before this child was born. And it was only raised, and it wasn't raised. You'll notice that it was raised by the other side only after this became a child support custody issue. Mr. Corns didn't raise this at the time that he had a relationship with her, didn't raise it at the time that they lived together with this child, didn't raise it at all until it just became a factor to be raised in a custody dispute. So it really wasn't a concern, and it's not like it was a change of circumstance in the sense that this predated the child. So yes, it's relevant in the sense that it occurred, but it's also known to the court because I believe that it was a Monroe County court case.
Okay, it was not known to this court. I don't know if Mr. Kuntz was aware of it. Mr. Corns, I'm sorry, was aware of it, or Mr. Savage, because it was not raised previously. So no, this court was not aware of it, but it is relevant. Ms. LaPrade, the referee recommend order simply refers that issue of custody parenting time to the front of the court, correct?
No, Your Honor, there was a hearing after the recommendation was completed, and there was a date provided to Mr. Corns to pick up the child. The day that the recommendation recommended he pick up the child is the one that Ms. Kuntz had objected to that brought us to you. And Mr. Corns was in Monroe County the day that referee Tomrich had told him to pick the child up. He was in our office.
Very well. The court would note, Mr. Rosenberg, Mr. Savage, that the court entered a consent order back on March 5, 2024, granting joint legal physical to the plaintiff mother. And the only issue was parenting time, and obviously the parties have not been able to communicate and schedule that parenting time. The court is of the opinion that we don't need to deal with physical custody. It's just a matter of a joint legal and then parenting time. So at this point in time, I think the court is in, we need to look at this further. Hopefully mother will participate with, now that she has assistance with legal counsel, she'll participate. And the court is reluctant to simply modify custody and parenting time without any type of hearing. So I think at this time it might be appropriate, and I just want to make the file clean, Mr. Pratt. So perhaps the court will rescind and cancel the referee recommended order. And I'd like the parties to discuss a parenting time schedule. As far as this court's concerned, we don't need to get caught up with the idea of the issue of physical custody. So the court will rescind and cancel the referee recommended order. The court will order that the parties share joint legal custody. And I'm going to have the parties talk with Mr. Pratt about a parenting time schedule that's going to commence very soon. So obviously, the child needs to be acclimated with the father. Perhaps is the child in school right now, preschool or anything, Mr. Olberg?
Yeah, yes, Judge.
She's
She's in young fives.
Okay.
Your Honor,
Obviously,
Your
the
Honor.
court would like the minor child to spend some time with dad, perhaps maybe over the Christmas holiday. Mr.
I'd be in
Savage,
favor.
is there anything you want to add?
I'd be in favor of that. As I said, we want Isabella to know her father.
Your Honor, in the room when we started discussing parenting time, I'm not sure how I would work out a schedule when Mr. Rotenberg said they needed reentry, so.
That's our concern. I want the child to not just be thrust with a stranger. Hi, I'm your dad.
That situation's
want
been
him-
created, Mr. Rotenberg. There's no undoing that situation at this point.
Right. So what I'm saying is I would like, this is my suggestion. We start some kind of therapeutic reintegration by scheduling some online through an app, faced it over the thing. Hi, I'm your dad. What's going on? What's going on in your life, Isabella? And whatever a father and a daughter would talk about, which I know is kind of awkward because it's like, I have kids, you have kids, you know what it's like.
Right. That could take months, Mr.
At least it's
Rotenberg.
not a strange face, but what I would say is perhaps we could do some kind of an overnight thing starting one of the long weekends in the winter after they've had a few weeks or a month or so of, hi, I'm your dad, hi, I'm your daughter. We do something
That
like
could take
that.
months. The best reunification is to have dad have immediate contact with that child. So I'm going to talk with Mr. Pratt for 5 minutes. If you can't reach agreement, then the court will make a decision. But and I understand there's a distance between the parties. Mr. Korn's residing in the Upper Peninsula, Ms. Kuntz residing in Temperance or Bedford Township. They can meet halfway, but the court believes this minor child should be integrated with his father by having physical contact, not over the video. So I'm going to talk with Mr. Pratt for a few minutes.
Your Honor, that would not be
You-
supervised, correct? The court would not be looking at a supervised situation due to the 8-hour time difference, I would assume, Your Honor.
That's correct. I don't know what I'm not sure Mr. Korn resides with, but unless there's some indication that his environment is inappropriate, no indication that Mr. Kuntz has an alcohol or drug problem. There appears to be no reason for supervised parenting time.
Thank you, Your Honor.
Yeah.
Your Honor, very savage.
To clarify, what I wanted was
I asked
the internet stuff to start immediately to hasten this.
Right, but Ms. Kuntz has not cooperated with that in the past. There was an agreement in the past that would happen and did not happen. So we're not going to waste time in that. We're going to have physical contact. And Mr. Savage, did you add something?
Yeah, Judge, he said.
Your Honor, I can understand everybody else, but I can't understand what you're saying.
Okay, I'm not sure. I'm standing right next to the microphone. We do have a new sound system. Has anyone else had difficulty hearing the court?
I hear
No,
you loud
sir.
and clear, Judge.
I can hear everybody else but you.
Okay,
No.
the court will rescind and cancel the referee recommended order. The court's going to order that the parties continue to share joint legal custody. And I'm going to talk with Mr. Pratt about specific parenting time schedule. And we can review it sometime after the first year, perhaps in late January, if we need to see how it's going. But the court wants the child to have some time with dad without delay.
Okay,
Okay.
see you in 5 minutes.
Virginia, back in the breakout room.
Trauma warnings echo through the room. Slow reconnection is begged for by a desperate side. Buried truths about the mother explode. The courtroom feels the weight of her past. The judge flips the entire direction. Everything changes in one powerful moment. Father gets immediate contact rights. No more delays. Like the video, subscribe to the channel, and we'll see you in the next video.